Hello, students. Now we're going to be looking at learning objective number two. And learning objective number two, okay, 10-2, is going to be discussing the legal context of human resource management and identifying contemporary legal issues. So let's talk about the legal context of HR management first. There are a number of laws that regulate various aspects of employee employer relations, especially in the areas of equal employment opportunity, compensation and benefits, labor relations, and occupational safety and health. So let's talk a little bit about what equal employment opportunity is. Title VII of the Civil Rights Act of 1964 forbids discrimination in all areas of the employment relationship. The intent of Title VII is to ensure that employment decisions are made on the basis solely on an individual's qualifications rather than on the basis of personal biases. The Equal Employment Opportunity Commission, EEOC, has responsibility for enforcing Title VII, that is the Age Discrimination in Employment Act, and the Americans with Disabilities Act, better known as the ADA. A business with government contracts must have on file a written affirmative action plan, a written statement of how the organization intends to actively recruit, hire, and develop members of minority or underused groups. Then, under the heading, and following along in your book, on compensation and benefits, we have what we call the FLSA, or the Fair Labor Standards Act. And what that does is it sets a minimum wage and requires the payment of overtime rates for work in excess of 40 hours per week. The Equal Pay Act of 1963 requires that men and women be paid the same amount for doing the same job. Now, ERISA, you may have heard that before. That's the Employee Retirement Income Security Act of 1974, ensures the financial security of pension funds by regulating how much can be invested. The Family and Medical Leave Act, FMLA, of 1993 requires employers to provide up to 12 weeks of unpaid leave for family and medical emergencies. Next, we have labor relations. Union activities and management's behavior toward unions constitute another regulated area. The NLRA, the National Labor Relations Act, also known as the Wagner Act, that's WAGNER, was passed in 1935. And what it does is it sets up a procedure for employees to vote on whether or not to have a union. The NLRB, the National Labor Relations Board, was established by the Wagner Act to enforce its provisions. Following a series of severe strikes in 1946, the LMRA, the Labor Relations Management Act, also known as the Taft-Hartley Act, was passed in 1947, and that was based on the part of the employer to limit union powers. Then the Occupational Safety and Healthcare Act of 1970 holds that every employer has an obligation to furnish each employee with a place of improvement that is free from industrial hazards that cause or are likely to cause death or physical harm. Now, there are other legal issues to look at. That is the AIDS in the workplace. Employers cannot legally require an AIDS test or any other medical exam as a condition for making an offer of employment. Organizations must treat AIDS like any other disease covered by law. Employers cannot discriminate against a person with AIDS, and they should try to educate co-workers about AIDS. Sexual harassment. Sexual harassment is defined by the Equal Employment Opportunity Commission as unwelcome sexual advances in the work environment. The employer is responsible for changing the environment by warning, reprimanding, or terminating the employment of the harasser if found to be guilty after an investigation. With quid quo pro harassment, the harasser offers to exchange something of value, such as a raise or promotion, for sexual favors. Lewd jokes, unwelcome comments, a work environment that is decorated with inappropriate photographs, and so on, constitute, under the Sexual Harassment Act, what is considered to be a hostile work environment. Harassment has been expanded to include unwelcome to inappropriate behaviors regarding ethnicity, religion, and age. We also have what's referred to as employment at will. The concept of employment at will holds that both the employer and the employee have the mutual right to terminate an employment relationship at any time for any reason, with or without advance notice to the other. However, employees can bring suit based on grounds of wrongful discharge. Then we have the Patriots Act. In response to the terrorist attacks of 9/11, the U.S. government passed legislation to increase its powers to investigate and prosecute suspected terrorists. The HRM implications are that certain individuals, including ex-cons and aliens from other countries, deemed by the U.S. State Department to have repeatedly provided support for acts of international terrorism, are ineligible to work with potentially dangerous biological agents. Other sections grant government investigators access to previously confidential personal and financial records. So let's talk, we said a lot here, or I did, but let's talk about some of the key points in Learning Objective 10-2. And that is to reiterate that protected groups consist of individuals who share characteristics such as race, color, religion, gender, age, disability status, and national origin, as indicated by a given law. Also, I want to reinforce the fact that sexual harassment includes quid pro quo, in which the harasser offers something of value for sexual favors, and a hostile work environment in which lewd behavior displayed by another employee is offensive. Also, just to reiterate that harassment definitions have been broadened to include age, religious, and ethnic harassment. Now, the other thing to remember, and we haven't gone over this, is that in a hostile environment where you have any type of harassment, whether it be quid pro quo or it be creating a type of very uncomfortable environment for any employee, the thing is that you have a right to file a lawsuit, and you have a big responsibility to come forward when these types of things occur, not only to protect yourself, but protect the safety of the work environment. I want students to also know that I am a Title IX liaison for any type of harassment that exists with faculty or students. And all I need to know as a mandatory reporter that the harassment existed, and I will make sure the information gets to the proper parties without incriminating you in any way, or making sure that what is said is held confidentially and that it is taken care of expediently. So this kind of concludes this section and Learning Objective 10-2. Now I'd like you to reflect on this section for about 15 minutes.